Welcome to another Facebook Live Lunch and Learn with the Center for African American Health. My name is Deidre Johnson, and I'm the CEO and Executive Director of the Center. For those of you who don't know us, the Center for African American Health has actually been around for more than 20 years. We are located in Northeast Denver, and we're also a new family resource center. We're committed to improving the health and well-being of the African American community, and we do this through community-based programs and outreach, evidence-based programs. We do a lot of focus on disease prevention and disease management, and to get them to the next step along their journey. So I want to encourage you to put any questions you might have into the chat box, and later on in our conversation, we will do our best to address them all. Today, we're going to talk about the topic of legacy planning. Some of you may think of it as estate planning and wonder how that connects to your health. But really, when we think about the social determinants of health and really looking at health holistically, we believe that getting our papers in order impacts our financial health and well-being, and that estate planning goes far beyond material assets. It considers your spiritual values, hopes, and ideals that you want to pass on to the next generation. So with us today to share the building blocks of a lasting legacy is attorney Michelle Adams. We're very pleased to have her. Michelle is also a mom and focuses much of her practice around the needs of parents of minor children. She likes to share information about the 5 essential documents every adult needs to have in place and why. So get ready to take some notes. I know I will be. Michelle, thank you so much for joining us today.
Thank you, Deidre, and thank you so much for having me on the Facebook Live. I'm excited.
So I want to start by asking you a few questions. First, explain why you include the term legacy as a part of your firm's description.
Thank you for that question. When I started the firm, it's been 9 years now, so it was 2011. And legacy then and still is that word that people kind of throw around, but really when they talk about it, you think about athletes or entertainers or people who have a certain amount of income or wealth. And so I believe that the little person, the everyday person, we don't necessarily think of ourselves as having a legacy. And I want to change that narrative to say, whoever you are, no matter what your income level is, no matter what your social status is, no matter who you are in the world, everyone has a legacy that they can leave. And you said this about the spiritual values, because people focus so much on the money and they'll say, well, Michelle, I really don't have a lot of money to leave. Well, it doesn't always have to be about the tangible things. It can also be about those innate gifts that we all have that we want to share and pass on to the next generation. So I was very intentional when I included the word legacy in my in both the URL for the website and in the work that I do in the community.
Thank you.
Yeah.
So who should create an estate plan and when should someone begin?
The magic question. First, everyone needs an estate plan if you're over the age of 18. And people hear 18, you're right, they say, wait, that's too young, I don't have anything. Well, the estate plan is not just about the will, it's about other documents that take care of what would happen if we should have an accident or somehow become incapacitated. So if you're 18 or older, you need some version of a plan. And I'll talk about what those components are. So the first thing that everyone needs is a will. Now, keep in mind that the major reason that people have a will to actually give their assets to certain individuals. So in the will, it states who's going to receive those assets. You're also naming the person who's going to take charge at the time of your death. So who's going to settle your estate? In Colorado, we use the term personal representative. In other states, you may be familiar with the term executor. Same thing, it's the person who's going to handle everything to make sure debts are paid and any income or any type of assets that are owed to the estate, that they will be received. And then the additional thing that the will do is name a guardian for your minor children. And this is really important for people who have children under the age of 18, because oftentimes, let's say the worst happens and mom and dad, or maybe it's just a single parent, they are involved in some type of fatal incident, and then the survivors are left scrambling to figure out who will take this little child. In some cases, everyone is raising their hand, which is good because, we know that we have a lot of people who are willing to take over. But what happens if there's some type of fight or feud between existing family members or friends? And so we want to eliminate that. Just indicate who it is that you want to serve as guardian, and then the court takes that into consideration when they actually appoint someone. So that's the will. The next essential document is the financial power of attorney. And this document comes into play, let's say if you are admitted to the hospital and you're now in a coma and you're not able to actually do financial transactions, or something else happens. You could even be away on a fabulous trip. Maybe not right now, but in the future, you could be away on a very fabulous trip and you need someone to transact business for you on a financial basis. The financial power of attorney is that document that's going to allow someone to do that on your behalf. Keep in mind that once you pass away, that financial power of attorney is no longer valid. So I've had people who've said, oh, I have this document, I want to go to the bank and, withdraw the money. And I say, has the person passed away? And they're like, yes. I said, well, you can't use that document anymore. You have to go to court and be appointed to be the personal representative. So that's the financial power of attorney. Then you have the medical power of attorney, and similar, if the person is incapacitated, that document will allow whoever you've selected to make medical decisions on your behalf. And again, the importance is you need someone who can advocate for you. So often you may have family members who feel differently about the course of treatment that you should receive. And the last thing you want is for two people, or for more than two people, to be fighting about what should happen to you if you're in the hospital and you can't communicate those decisions on your own. The fourth document is the living will. This is also really important because if you've ever seen a situation, and nowadays in contemporary times, I talk about Bobby Christina, Whitney Houston's daughter, who died, at such a young age, but she was kept on life support, I believe, for a period of up to 6 months. I suspect that that may not have been her wish if she had actually communicated what she wanted and how long she would want this to happen. But when you have family members who are, first they're in shock that they have this young person who's in this situation and they're not willing to let go, I think oftentimes we hold on to people much longer than we're supposed to because we don't have the we don't have the fortitude to make that decision to say, I think it's time to remove them from off of life support. So the living will takes all those decisions out of someone else's hands, puts them back in yours while you're able to communicate what you want, and allows yourself to make those decisions as to if you want life support, and if you do, for how long. And then go ahead.
Good question. So if you have a medical power of attorney and a living will, do folks kind of compare that to make sure that?
Exactly. Yes. So you want those two documents to act in tangent. So the medical power of attorney is a separate document solely naming individuals, and then the living will, separate document solely indicating what your preferences are regarding end-of-life care.
Okay.
Yeah. And then the fifth document that goes hand in hand with those medical documents is a HIPAA release. And we know that anytime that we go to a doctor, there's a stack of paperwork that they give us, and typically one of those forms is a HIPAA release. And that HIPAA release will allow you to share your information with a third party. And so you want to make sure whoever's serving as your medical power of attorney also is named in that HIPAA release so they can actually access your medical records.
Thank you. So share with us what happens when someone doesn't plan.
So that's the fun part, because I always tell people there's always a plan. There's either the plan that you proactively make, or there's the plan that the state, in this case, the state of Colorado, has for you. It's the default plan, which is the law of intestacy. So when someone dies, as an example, without a will, then state law kicks in and says, okay, what would be the natural order of who would have received this person's assets had they left a will? The order usually looks at first spouses, they look at parents, children, and then it extends to siblings and other cousins, aunts and uncles. And in some cases, that could be exactly what you wanted. So let's say you didn't have a will in place and you were married, or you had children and that's who you wanted to receive your assets. then it would fall according to your wishes. But let's say you have a unique family dynamic, which most of us do. There's always something. Everyone has a family situation that's not always so black and white. And you may want to not leave assets to a certain individual. Maybe there's a concern of substance abuse or something along those lines, and giving money to that individual will actually create more harm. But there's nothing you can do about it at this point because you're no longer living. So without a will, your default plan is whatever the plan of Colorado has. I do want to debunk one myth though, because so often I hear in my practice, well, I don't want the state to get my money. And I tell people, well, the state's not going to take your money. They're going to look for whoever the next relative would be. However, if they can't find that person after a certain amount of time, then the money would revert back to the state of Colorado. So it's just something to keep in mind.
Okay.
Yeah.
And in the case of having minor children, what is that? Intestus?
Yes. Yes, I know. All these Latin words that we throw out there. Yes, so exactly what happens is if you don't have a guardian named for those children, then the court has to determine who would be the proper guardian for that individual. Again, in some cases, it may not be an issue. If you have the child's other biological parent and it's somebody that you would have felt completely comfortable with, then fine, that's what you want. But supposing there isn't another biological parent, maybe both parents, perish together, and now you have different branches of the family. You have the paternal side and the maternal side potentially coming into conflict as to who should have the child. And keep in mind, not that this happens all the time, but when there's money involved, then things get a little interesting, to use the term lightly. And then let me just add this. If a person dies, or if a person is hospitalized and they don't have the proper medical documents in place or the financial power of attorney, once again, a court may have to intervene to say, we need to appoint someone as guardian or as conservator over this person's assets. And I always stress that what could have been a relatively lower cost if they had pre-planned becomes a very expensive cost once you have to bring the court into the situation.
Okay.
Yeah.
What do you think stops people from creating a plan?
A few things. One, I believe it's a fear that all of us have, that by planning, that means that we're planning for a death, which means that somehow or another, I'm going to usher death in that much quicker. I've heard that before. And so there's that piece of it. But we all know that at some point, we're all going to pass away. So again, let's just take that off the table. Let's just go ahead and make the preparation. I think the other thing is it can be overwhelming for people to actually sit down and think about, what are my assets? Who do I want to leave them to? Who do I want to name as a guardian for my child? It can just be overwhelming for folks. So I believe that stops a lot of people as well. And then finally, I think sometimes just the thought of having to go to an attorney, which, for some people, it's like, no, thank you. It may be intimidating, whatever. And for me personally, I take that off the table. Just like we're talking here, this is how I like to talk to my clients so that we're all at ease. And I recognize that I call it a privilege to be able to come into a client's life because they share so much about what's going on. And I think that's partly it too, the fact that they have to share perhaps some things that they'd rather not disclose.
That's totally understandable.
Mm-hmm.
So many of us have aging parents or elderly relatives, and sometimes they are not eager at all to discuss these kinds of things for many of the things you mentioned.
Yeah.
How can we get the estate of an aging parent or relative in order, and when does this need to happen?
Yeah, thank you for that. I would say that first, that is, again, one of those interesting dynamics because, you were used to the parent being the one making the decisions, telling us as the children what to do, and then the roles reverse, where the children become more like the adult. And it can be awkward because you're not used to telling your mom or dad, this is what needs to happen. That said, it needs to happen. And so one of the strategies that I encourage clients to use, or people who call me about this situation, is to say, let your parents know that you're in the process of getting your documents in place, and open up the conversation that way by saying, I met with an attorney, we're getting our estate plan in order. What are you guys doing? Have you considered doing that? And then it takes it away from you need to do it to I'm doing it. What are you planning on doing as well? I would say also one of the other things to keep in mind is that the generation, our parents' generation, is one that kept a lot of things private. Let's keep everything kind of close to heart. We don't want to reveal too much. And
Right.
so we have to be patient and understanding of that as well, that there is a certain level of distrust as to why do you want to know? Are you trying to, kill me? Those thoughts go through people's heads. So we just want to reassure them that it's not just them, it's all of us that need to plan as well. And, even my own parents, and who knows if they're even listening, but bless them, because a few years ago, they decided they live out of state, but they said, you know what, it's time for us to get our documents in order as well. And so they took the necessary steps. And what I will say is, even though it can be a challenge for some individuals, as we're talking to our parents about this, it's the best thing ever, because it opens the door for additional conversation, not just about the money, but also to get to know your parents a little bit better and to understand perhaps what their values were and things that they want to share with the next generation. And one final tool that I want to make sure people are aware of, it's an organization called the Conversation Project. And I believe they are based in Boulder, and they have tips and strategies for how to broach this topic with, your aging family members. So I think that's a great resource for people to tap into.
True. And on a personal note, it is better to do it sooner than later, because before he passed, my father had undiagnosed dementia. And so that type of conversation became very complicated, given what he was going through.
Absolutely.
So I have, oh my goodness, my oldest is about to turn 17.
Ugh.
I've got about a year, given your recommendation. What do you need to do to prepare an adult child who's going away to college?
Yes. So, been there, done that. And it's very important for us, again, to remember as parents that we were the ones taking these kids to the doctor's office. So we knew exactly what was going on. We had all their medical records. Something magical happens at the age of 18, where the law has now said, oh, these young people are now completely responsible for doing these things on their own. And guess what, parents? You don't get to find out what this medical information is. And so what I have found helpful is to have that conversation with our young person to say, listen, we're going through a transition time. I know it's very confusing. It can be overwhelming for you as well. One thing that we want to make sure that we have in place is, in the worst case scenario, something happens to you and we need to access not only your medical information, but also your financial information. So I have established what I call my young adult protection package. And that includes powers of attorney for financial and medical, a HIPAA release, and then also instructions about what should happen if it's end-of-life decision-making time. And I will say I've had a handful of clients who fall under this category, and one individual actually passed away about 2 years after we created his documents. And the parents, came back to me later to say, thank you so much, because as a result, we were able to know what it is that he wanted to do as it relates to that decision-making time. So even though it's the worst thing, no parent wants to think about their child dying or being in a situation where they have to make these hard decisions, it's really important that we have the conversation with them so that we know what their wants would be.
Very true.
Yeah.
So tell me a little more about your process.
Yes. So pre-COVID-19, we would gather together. Clients would come to the office. We'd have a conversation about what their goals were, what their objectives were, and then based on what they were trying to accomplish, I would come up with a plan that met their needs. Now, thankfully, we can use technology to accomplish pretty much that same, to get that same goal accomplished. And so I meet with individuals most oftentimes by phone, sometimes by video conferencing. just depending on the capability. But the biggest thing that people should know is that the process does not have to be so overwhelming as we make it out to be. And I know that one of the best things I ever hear from my clients is, thank you, you made that process so easy for me. I didn't think it was going to be that easy. And to me, that's what my intention is. That's what my goal is. The other thing to keep in mind is that typically from the time that you meet with the attorney, I'll use myself as in this example, from the time you meet with me, it would take about 2 to 3 weeks for the plan to actually be drafted. And then at that point we review, make sure there are no changes. If there are no changes, then we would go ahead and have that signing ceremony. One of the biggest mistakes people make when they do it themselves is that they always forget some of the formal protocols that have to happen. And so we just want to make sure that everything is in order the way it's supposed to be. The other thing that people should know, at least with my process, is that once everything is signed, then you receive the original copies back. It's really important nowadays that the attorney does not hold on to that original version, because you just don't know what could happen to me or, to those documents. So I retain a copy for my own records, but send the originals to the client so that they have them for their files.
Okay. And how much does it typically cost?
So everything I do is done on a flat fee basis, and it's all in a package. And depending on the circumstances, the package at the low end, if you are a single individual, could be $1,250, so $1,250, all the way up to about $4,000, depending on the level of planning that you need. And at some point, people have heard about trust and they think, you know what, I want to have a trust established, and that's great. And with the trust comes additional cost. And for some people, it makes sense. And for other people, I will look at the situation and say, here's my recommendation. You can decide that you want to go ahead and do more extensive planning, but you can probably be all right if we land right here at a less expensive option.
Okay.
Yeah.
So once we get ourselves organized and get this done, how often should we reevaluate?
Ooh, yes.
As life changes?
Yes. So I always tell people, think about those life transitions. And I believe it was the American Bar Association that talked about the Ds, the 5 Ds. So D as in dog. And one of the Ds is death. So death of a family member, friend, or a loved one, or even someone named in your documents. Disability. So let's say you have an injury or you're diagnosed with something. You want to make sure that you update and review your documents. The situation of divorce, definitely a time to make sure that you're looking things over. Decline in health. So once again, something's going on. You want to look at your planning. A new decade. I say anything that ends with a 0. I had one of those a little while ago. Yes. So you want to make sure you have that. And then also domicile. So if you change, and not so much within your home state, but if you move to another state, you definitely want to have those documents reviewed by an attorney in that other jurisdiction.
Okay, that makes much sense.
Yeah.
We've got a couple of questions.
Okay.
If you're an older person and still work and would like to include a nonprofit in your will, how do you do that?
Love that. So a few ways you can do that. What I would first speak to is you might want to consider actually naming the nonprofit in another type of plan. So it could be an IRA, a 403B, a life insurance policy, things along those lines, where you're assigning a certain percentage of that asset to the nonprofit. The other thought is you can just name that nonprofit directly in the will. I worked with a client and she had literally about 10 nonprofits that she wanted to, in fact, the nonprofits were the major beneficiary of her assets. And so in her situation, we had set it up as a trust, and then we named the nonprofits as beneficiaries of the trust. But you can absolutely do that in a will as well.
Okay. Do you have any tips on how best to settle issues with splitting up assets among family members, like inheritance among 3 or more siblings?
So I'm going to make the assumption that there was no planning done, because if there was planning, then the will would say who receives what. Now, let me make this other assumption. Supposing it's a parent who's saying, I'm in the planning stages and I want to know how I should split those assets up. the best way to do it is to look at it a third, a third, a third. If there were three, we're looking at three equal siblings. But sometimes parents may feel like, you know what, I really want to benefit one child more than the other because perhaps one child is really well established and they don't need the money. Perhaps then I want to dedicate more of those resources to the other child. It could also be a situation where there's an age disparity. So let's say there is a 10-year age gap between the oldest and the youngest, and you want to make sure that if that parent dies, that the youngest potentially gets a little bit more because they have not had the benefit of receiving gifts from the parents, when they got older. So there's some creative ways to do it. But if this is a situation where there was no planning and now it's three siblings trying to figure out the best way to split the property, the biggest thing I can say is come with an open heart and with the proper intention, right? So my hope is that everyone wants to see their siblings inherit at the same rate that they're inheriting. And so come to the table saying, let's do what's best for our family and ultimately to preserve family relationships, because that at the end of the day is what matters. Those assets will rust out and be spent in the whole bit. And if you don't have that relationship with your loved one, what was it all for?
So true.
Yeah.
Another question, what should I consider when having joint ownership of assets with my spouse included in my asset planning, estate planning?
Yes. So spouses, have a special category within the law. So first of all, if the property is owned joint tenancy with right of survivorship, that's one way a lot of real estate is held, then at the first person's death, the survivor will automatically inherit everything, regardless of whether or not there was a will in place. Mm-hmm. I've seen situations where the two people were married, the property was only in one person's name, the other spouse did not know that. And so when that person died, now that property had to go through probate. And because it was a blended family, the spouse did not receive everything. The other children received something as well. So you have to be really intentional to make sure, especially in the situation of a blended family, that the outcome that you're wanting is the outcome that actually is written out clearly and plainly for individuals. The other thing is for a lot of folks who want to make sure that they give the spouse an equal share, looking at life insurance policies, making sure that you've named your spouse, in most cases, as the primary beneficiary, whether it's for, again, investments, 401k, mutual funds, etc., as well as those life insurance policies.
Okay. In this age of the internet, there's so many things at our fingertips. So if I were to fill forms out online, would I still need an attorney?
Yes, please. So, and I'm thinking you're talking about like estate planning forms, because there are a lot of, sites that, plug in some information and then an estate plan magically appears. And while in theory, that's not true. I think you get what you pay for and you just have to be really careful. So as an example, I talked with someone who was relatively young, had no children, had no property, and that person wanted to know, could I use one of those online systems? And I said, you know what, in your situation, there would probably be no problem with that outside of anything else that I'm missing that you haven't shared with me. But anytime you talk about children, anytime you talk about property that could also be in another state, you definitely want to have the benefit of speaking with an attorney to make sure that you're on the right path, because there's so many little tricks that are out there and ways that you can kind of trip yourself up, that you just want to make sure that you're doing the right thing and not defeating the overall purpose and outcome you were hoping to achieve.
Wonderful.
Yeah.
Thank you so much. It's amazing how many topics you have to take into consideration. Yeah. It's also interesting how you can never assume that things will just work themselves out. I also share, I was helping my mom recently because it turns out that my great-grandparents still had some farmland in Oklahoma.
Wow.
So there was an attorney calling her, and I was trying to figure out why are you trying to reach her, and everything worked out. But I'm sure the level of effort that had to go into kind of tracking down 7 families and figuring this out could have been dispensed with.
Absolutely.
But it all worked out.
Yeah.
Let's see. It's already 12:30. This has been fantastic. Thank you so much.
You're
I'll,
welcome.
I'll definitely be in touch.
Those teenagers, yes, we got to get it all together.
Exactly.
Yes. Please feel free to reach out to me at any time. And thank you for allowing me the opportunity to share what I believe is, critically important, not only for our community and our overall financial well-being, but tied into the health component as well. Because when we have one less thing to think about, it just takes the stress away, and we can, find other things to focus our energy and attention on.
Right.
Yeah.
So thank you all for joining us today. As we discussed, this is about so much more than just assets. It's about your family, what you value, what you want to leave for folks, and relationships. So we look forward to joining you again next week. Have a wonderful day. Have a fantastic holiday, and please stay safe.